G'day, Nina. How are you?
Good, thanks,
You
Andrew.
gave me
How
a
are
second
you?
glance there. That was a bit of a worry. Well, we've got quite a lot on today. We've got some very exciting stuff about a Victorian Court of Appeal decision, which tells us where the fines and the custodial sentence in industrial manslaughter cases, probably for Australia,
Yeah.
really helpful decision, I think.
Massive fine.
Massive fine, and we'll talk more about that. Let's not spoil the fun there. That's our major topic. But one of the things that excited me today, we had our firm hookup, which is with everybody on the screen. There's faces everywhere. But the thing I loved about it is that younger practitioners, that's everyone under 40 for me, are all doing court appearance work. And our clients love it, but it's also, and you're doing it, you're doing pleas in OHS matters and stuff, which is really exciting. But it is lovely to see a group of practitioners excited about appearing, not just shuffling paper, isn't it?
Shuffling paper. Well, yes, it is nice to do other stuff.
That's how I started my life. I started my life doing all my own appearance work, and gee, it teaches you what fails, doesn't it?
Yeah, I think it's real good learning because you can't prep for everything. There's going to be cases where they just challenge you on the spot and things like that.
And the other part is it does teach you what works and doesn't work. So it's lovely when you're getting instructions from someone to say, look, I know you feel that, but it's not going to take us anywhere. This is what matters. So I was really excited. I love having our firm catch-ups, as you know. I sort of get a real kick out of seeing all the faces there. But what excited me most was seeing Laura walk in the room after just winning in court, and I thought, that's who we are. Isn't that just great? The Cuban tractable bargaining case is a really interesting case. It shows the Fair Work Commission's willingness to rely a bit on very experienced bargainers, I thought, and also to say, look, I know you're doing a good job, but on the key issues, you're still miles apart. I think I better intervene. So maybe you talk a bit more about the facts, but I think this tells us how intractable bargaining will be used as an application and will succeed, and what won't succeed as well.
Yeah, well, I think it was a really interesting case because it's very different from the previous cases we've had where there were parties on opposing sides, whereas both parties in this case seemed to accept that an intractable bargaining decision was needed because it'd been 10 months that they've been locked in negotiations and they just couldn't get agreement on key issues like pay rates, income protection, I believe, sign-on bonus, things like that.
Yeah.
And there was no point in doing further negotiations, which you can do after intractable bargaining, because it just wasn't getting anywhere.
Yeah.
So it was really the ripe, perfect example.
And I think what it does show is what the provision was meant to do.
Yeah, exactly.
Where parties are warring, there's still industrial tools that you can throw, and that's what other court cases have said. Well, look, you're in dispute, but you've got tools to use.
Yeah.
You've got to exhaust those tools.
Yeah.
But these two parties came and said, look, we are apart. Actually, we know we're close to being together, but we agree on everything else.
Yeah.
I think it's a great outcome and a really interesting case to demonstrate what this provision is meant to be.
Yep.
And as industrial advocates, when you're there representing your business, it also tells you how to refine the issues down. You come to wages and money last, you don't do them up front. And when you are stuck, you're able to say to the union, who are experienced negotiators, look, are we too far apart? And this is what's so important in this case is, what is the evidence you have that shows that what you're offering is reasonable? So don't get into intractable bargaining dispute you're going to lose. Draw yourself into that position where you know the Commission is going to back what you say, because that's the trick. And I think that's sort of what Cube were manoeuvring. I don't know, because Cube have been a bit all over the place.
They did quite well with this one. It was like the first example where they've done it right instead of using it to try to force the other side.
Yeah. Okay, look, I think that's good. I guess one of the things we forget in safety law is that you're often caught in very difficult situations in safety law where there is an okay choice but has risk and a good choice. But under pressure, you choose the wrong one. And I don't like this case.
No, I don't. I thought it was kind of unfair.
So what's the name? We don't actually have a name, do we, for this case?
No, but essentially what happened was a vessel master, which I think is a very cool title.
Yeah, I want to become a vessel master.
There was an emergency with one of the divers and they made the decision to get them back to shore.
It was a medical condition, so it was something that had to be addressed. But there were divers still in the water as well.
Yeah, including an instructor, and the vessel master left them all there to prioritise the person who was in medical distress.
And that was a 30-minute gap between coming back. And I don't think this should have been a plea of guilty.
No, I feel like it was unfair for them to bring the case at all, because even the court was like, look, yes, best case scenario, you should have loaded everyone into the boat, counted everyone, and then gone to the medical emergency. But also, split-second thinking, you're just trying to save someone's life.
And the other part is it was the individual who was charged in this. So it was actually the vessel master who was charged. So I think this is bad law, okay, because what the vessel master's obligation was to exercise reasonable care to prevent risk of injury to themselves or others. I don't think this is the devil's choice.
Yeah.
No matter what they did.
Sophie's choice.
Sophie's choice, is that it? It's the devil's choice for me.
That's a movie.
Yeah, because you can't get it right. Now, if the person had have died because they hadn't have gone into shore.
Exactly.
So I think this is a charge that should never have been brought. But the problem in safety law is you have a great big organisation charging an individual. They don't have the capacity to fight.
No.
But they should have fought because this is a flawed decision, okay? So you'll read about it out there. The reason Nina and I have got it on is it's a bad decision and it should not have been brought as a charge and it should have been defended. There are times in safety where the choice that you're faced with is an impossible choice. And I don't think the choice was a bad choice. Maybe his lack of communication around it to others may have been a risk in it, but it's a bad case. Great case on flexible work. Yeah, so this is the National Bank case on flexible work. And this was a person who had a flexible work arrangement.
Yeah, they had to come to the office one day a week, to the national office one day a week. And I think, what was the other one? That they had to check in. Oh, then the rest was just work from home.
Yeah. And what happened is that the woman involved, Kelly Foster, didn't come to work on the one day that she was required to come.
Yeah, they didn't see any swipe access to the main office, so they determined that was evidence that she had never come in.
Yeah.
Yeah.
And you'd have to get in there. So I guess that's the only way through. But whatever it was, the question came as to whether the decision of National Bank was a matter that could have been dealt with under the Fair Work provisions in flexible work. And what the court said is, no, there's no provision under the Act to deal with the termination of an arrangement. So this is sort of odd because...
Yeah, that's what I thought was a weird case.
Yeah, I mean, all she had to do was to put it back up again and then it could have been determined. Does that make sense?
Yeah, because she brought the claim under a section that was to deal with whether National Bank could have refused the request or not. But what they did was they terminated the request because of what she did. So the case didn't focus at all as to whether she did break the agreement or thing. It's just they said she should have brought it. We don't have
jurisdiction.
Yeah, you should have brought it under like a dispute provision instead.
That's right.
It just seemed like a little bit of a cop-out.
Yeah, and I think it's more than a little bit of a cop-out. I think that our Fair Work Commission from time to time has to look at the practicality of what people are doing, and small individuals feeling wronged against large institutions actually do deserve a little bit more protection than no. They don't. That's sort of what I think. So I'm not really particularly happy in the way this was navigated, but we weren't there listening to the arguments that were being put.
That's true.
But there was a dispute process that could have been dealt with, or equally.
And potentially that might be the way that she goes now.
Yeah.
Like that's still open to her.
Or he could have said, well, will we agree to deal with this as you're making a fresh application? I deal with it in those terms.
Yeah.
And I think the National Bank, even at that stage, would have realised it's looking a bit bleak for them. But they could have won based on what had occurred in the past. And they should have just run at it. But instead of that, we've got this inflexible decision on flexible work, which takes us nowhere. So under flexible work provisions, there is a dispute provision where you're fighting over it. So that's an argument you can run, but you can't actually bring an application about whether it is a wrongful rejection of a flexible work in relation to one that is existing. So
yeah, and I feel like the more appropriate way to deal with this as National Bank should have just been, as soon as they became aware of this, to issue lawful and reasonable directions as to how that she has to go to correspond with it. Otherwise, she would then be in breach of it.
So yeah, this starts off a process which is awful, rather than just deal with the issue at hand. But look, an interesting case once again, because Nina and I are aware that cases are sometimes misunderstood for what they are. There is a process. It wasn't done. Chose the wrong process, knocked on the head. So the case doesn't really stand for anything except the Commissioner or the Deputy President failing to put their hand up and say, maybe I can help you. Bullying claims. Now, this is a Fair Work Commission case. Aorta, I love that, isn't it? Aorta is a great name. It's the artery that goes to the heart. Anyway, whatever it was, this was a bullying application made by a separated wife against a husband who was the director, isn't it?
Yeah, so this was really messy. Essentially,
Doesn't get messier than this, does it?
oh, I feel like this was
This
very
is days
messy.
of our life stuff.
Yeah, it really was, because the husband owned the company, but then married his wife. She became CEO. And
Married a person who became his wife. I don't want to spoil the grammar. I think marrying his wife twice was too
all
much,
right.
don't you?
Okay. And then he stepped away from the business, and then they separated, and things got very toxic. And she said he was bullying her. He threatened to punch her in the face.
Then there was an immediate apology, can I just say? An immediate apology.
Yeah.
Bit late though, really.
Excluded her from things and all these other allegations, but she refused to enter into any kind of mediation or attempts to try to reconcile their working relationship. She brought a stop bullying claim, and it was completely dismissed. Look, I think the fact that he threatened to punch her in the face is pretty bad, irrespective if he apologised afterwards. Like, it's a workplace.
Can I just say, but this just shows, once again, without being too critical, that was seen as a once-off incident.
Yeah.
And therefore it couldn't be bullying, but
Yeah,
ignored everything else that did
yeah.
occur. And once again,
I didn't think this was a good decision at all.
yeah, no, look, I'm struggling a bit with the decision, but I think the decision is trying to manage two very complex souls sitting in a
Yes.
room who hate each other.
Yeah.
And really, the answer, the real criticism here is at the CEO who failed
Which is the wife.
failed to adopt any mechanism to resolve it.
Yeah. But I feel like they should have just set it for like a mediation process.
But I'm sure that's happened though. I'm sure the conciliation
rather than being like, because you didn't do this, it's not bullying order.
Yeah. I don't think the law in this has been great. So I don't think the Commissioner's understanding the law is great. And I think that anyone who holds up a fist, even though they apologise afterwards, doesn't change the violence of the act.
But also the safety aspect of it. Like, you can't do that.
Well, it's terrible. I mean, the issue is stop work orders were designed to circumvent the overuse of Justice Acts and Crimes Acts intervention orders. So it was designed to actually prevent that and actually deal with the issue as it was alive. And this has left them back to crimes, to criminal intervention, which is not what it's about. So it's done. And Nina and I have dealt with a lot of cases that have been brought to reduce the redundancy payment.
Yeah, and they're
TAE
often not done for the
Aerospace,
right reasons.
yeah, this TAE Aerospace and David Vanner is another one of those cases where you just sit and look at it and you go, who advised Aerospace to actually make the application?
Yeah, and
like it's a nonsense.
It wasn't worth investing the time and resources to bring it. And I think the audience will agree when they hear the facts.
Lesser job?
It was the guy was an engineer, and he was undertaking a secondment with one of the associated companies as a business development manager. They realised...
An executive role?
No, his engineering role was an executive role.
Yeah.
So they realised they didn't need his executive role anymore, and so we're going to make him redundant, but offered him the business development role in the associated company, which required him to spend more time away from his family, his young family, was lesser pay and a lower rate. And he lost out on all the bonuses from his executive role. And so he very reasonably said no.
So what do you think at home?
Yeah.
when I read this, I sort of looked at it and went, 1, 2, 3, 5 things that make this worse than before.
And he worked
How could it be acceptable?
For 10 years. This is how they treated this guy.
Yeah, they lost, by the way. They just got cleaned up.
Yeah, so they have to pay him the full entitlement.
Yeah. Anyway, can I just say, when it comes to looking at reducing redundancy, it's a big decision. You've got to spend quite a bit of money to have an argument, which sometimes is over 5,000 or 6,000. This is over a lot more. I understand that. But surely at some stage you look in the mirror and say, old job, new job, gee, it's nothing like it. I'm going to get cleaned up and I'm going to destroy the brand internally in the business because someone who's been there 10 years has 10 years worth of friendships they're going to talk to and say, look how they treated me.
Yeah. It's also an extremely high threshold because you can't just unilaterally do it. You have to get permission from the Fair Commission. And I think there's like a handful of cases where that has happened.
Yeah. Anyway,
so
look,
don't bother.
We've got funny cases this week, haven't we? Funny cases.
You pick them.
No, I did pick them. That's true. Okay, now this time we're going to go on to the final, aren't we?
The main topic.
Yeah, well, let's go on to the main topic. What can I say about the most recent industrial manslaughter? It's workplace manslaughter in Victoria, where we'll talk about a case, the LH Holding case, and we'll drill down a bit more in a second. But what I want you to understand about this case is this is really turning a corner. This is not a case which is just another sentencing case. This is the Victorian Court of Appeal, which is a highly recognised court of appeal on safety law. And remember, there are more safety cases run and litigated and appealed in Victoria than any other state. So this is a jurisdiction which is renowned for their judgments on it.
Yep.
And when we talk about sentencing, when a judge is sentenced, we talk about tariffs. That is, what is the bottom and the top of averaging sentencing for a wrongdoing. Now, in this case, what we've got is a forklift that turned over. What to do? It knocks.
Oh, so the sole director was lifting an A-frame using a forklift on a sloping hill.
Yeah.
And then it tipped and the mast fell onto this other worker who was helping him and fatally crushed him, essentially.
Yeah. So at the beginning, the appeal was done by the Department of Public Prosecutions. There was a $1.3 million fine, which the
original fine.
Yeah, the original fine, which could never be paid in any circumstances, and there was 200 hours of.
Yeah, so both
correction.
parties, both him, the director, and the company were convicted, and the director also had 200 hours of unpaid community service and a community corrections order, which was suspended for 2 years.
2 years, and there was $120,000 judgment for the sister who.
Compensation. They had to pay for the sister.
But what I want you to understand about this is, okay, this was not a high order breach. Okay, so when we look at breaches, first of all, you're going to have a breach of duty, so the breach of duty is there. But then it is the highest level of negligence that attaches to that. This is just inside the industrial manslaughter breach, okay?
Well, I think the court said it wasn't on the lower end.
But it effectively is, to be candid with you. It's anything less than that's reckless.
Because it was like a couple of seconds.
Yeah, a couple of seconds. But my point about it is, even if it's the middle, what do we know about the sentencing now? We know for this relatively, it's terrible, it's fatal, but it was a couple of seconds, it was bad system, it was like
also a one-time thing. They hadn't, it wasn't a repeated practice done over multiple
So there
times.
you go, you got this. So I'm saying it's on the lower order, but it's certainly not above the middle order of industrial manslaughter. And you got a $3 million fine.
No, it was 1.3, now it's been increased to $3 million.
The Court of Appeals raised it to $3 million and has not dealt with the other orders. But my point about it is $3 million for this means that a high order breach is somewhere between $5 to $10 million wherever you go, okay? And community correction orders is definitely jail for high order breaches. So where there's a systems breach, where there's a known risk, where people fail to take notice of that risk and there've been other pre-ones where people are nearly, that stuff is off to jail, and we can assume off to jail for some time. Because we do have reckless endangerment, like Jackson's case, where there's been 1 year's jail. So we now know in serious risk industrial manslaughter cases, the bottom line is 1 year jail, but could be significantly more. And we know the fines will be 5 up to 10, maybe more, based on the serious nature of what occurred. So this case changes the game, because prior to this, we've had a couple of $3 million and $1 million and stuff, but this one sets the tariff. It takes the trouble of saying where the wrong was and what is right in sentencing tariff for the wrong. And as the most senior jurisdiction, because it deals with the most cases and the most relied upon jurisdiction, it tells the rest of Australia, okay, well, Victoria has $25 million as a penalty, 3 for low order, mid probably 5, very serious, 10 and above. It is going to change the way regulators prosecute, and it is changing the tariffs for Australia. So I think this is a really important case.
Yeah, I think it's a big warning to everyone, particularly after we saw those new sentencing recommendations, that the regulators are really trying to increase the fines, and so are the courts, really.
Okay, so there we go. Okay, Nina, the case study.
All right.
Bit of a dark one today,
I know. I called you right after reading it. I was like, gosh, this is morbid. Nadia was the CEO of an advisory business called Accumulate, part of a first-tier accounting firm. Acuminate provided corporate advisory, business broking, and a range of people-based analytics. There were considerable pressure to hit financial targets at Acuminate, as the accounting firm had suffered both brand and financial damage due to government contracts. Nadia and her leadership team felt the pressure. Her corporate team leader, Conrad, a member of the executive, was a former partner in both the accounting firm and previously in a successful banking business. He was from another generation, fast-working, emotionless and driven.
Not like me.
I was literally just thinking that. His team had rated him below average.
I'm feeling a bit depressed now. That was trying to show I was different.
In the annual review, and recently Sienna, a manager reporting directly to him, had raised an incident reported claiming psychological hazards were impacting her mental health. HR raised the incident log with Conrad. They explained that Sienna had previously raised concerns with him. His instructions lacked clarity. The volume of work he required her to do was excessive, often given late in the day with early deadlines. He treated her male contemporaries more generously in a matey and forgiving manner, and he was often disrespectful to her. HR had facilitated this conversation. Despite her speaking up in a generous and respectful manner, he was now targeting her, challenging her agreed work from home arrangement and disparaging her to co-workers. Her work volume had increased, but much of it was beneath her skill level, which was demotivating and hurtful. Conrad simply told HR she was a dud and that they needed to get rid of her. He said that her billings had dropped as he had to write off so much useless production time and that she was not trusted or liked by her peers. HR advised Nadia of his response and she met with Conrad. She explained that he needed to pull his head in and act properly with her. There was no evidence in her reviews to support any of the complaints he now made, and other leaders respected and trusted her. Conrad was dismissive and said she needed to reflect and listen to him, but he would be more careful. 3 days later, in the midst of a major transaction, Conrad had Sienna undertake hours of low-grade work in the audit room for due diligence. Her fellow workers had noticed she was regularly in tears, terribly tired and sad. They had noticed she was given all the worst jobs, and when one colleague, Karen, raised it with Conrad, she suffered a stinging rebuke. Tired, sad, depressed and anxious, Sienna walked out of the office to get a cab at 1 a.m. and was struck by a tram and died. People who saw her said she looked like an automaton.
Automaton. I always stick in,
Automaton.
somebody.
A robot?
Yeah, robot. Yeah, I could have said robot.
Just use robot.
No, but I always put one word in for you every time.
You're such a lawyer using
I'm
unnecessary words.
Such a lawyer. Okay, so the first question is, did Sienna have a strong workers' compensation claim prior to death? Absolutely. So,
it was clearly linked to her work.
Yeah, clearly linked to her work. So it was causative.
Not reasonable management action.
Yeah, well, it didn't need to be. It was her experience of behaviour dressed towards her, which was non-performance related. So it's subjective. So she was up. In relation to any, if you wanted to allege, it's certainly the actions of Conrad were not reasonable in respect of her actions and not reasonably done. So no matter which basis you look at the workers' comp claim,
there was no way. Yeah.
She's across the line.
Did Sienna have a strong general protections claim prior to her death?
Now, so this is I've chucked in a Burke and Son Corp. There's no doubt at all that if we look at the last part of the problem.
So you're saying if she was terminated or just like a non-termination?
The way she would know, non-termination.
Okay,
yeah. So that's a good question in some ways. You know, for general protections, it has three different unfair dismissal, practical ones. One, anybody can be joined as a respondent to it. So it can be the organisation, it can be Conrad, it can be Nadia. That's one. The second issue is that
there doesn't have to be dismissal.
Doesn't have to be dismissal, can be done in respect of the behaviour that's occurring. Yep. And finally, there is a reverse onus. So once it's alleged, then the employer and the respondents have to prove it's not so. Now, in this case, 2015, Burke and Son Corp said, look, you can become aware of a person's particular attribute that is protected under any form of legislation. So legislation protects someone with an injury or illness.
Yep.
Here, if a reasonable person could have observed that she was anxious and unhappy,
which was very clear by the
symptoms,
very
clear, then any behaviour that directed her to do work under those circumstances would be based on a subjective intention to give her work with the knowledge of that, even though it's imputed. And at that stage, you've got a general protections claim.
She complained, and then he took adverse action against her. He didn't terminate her, but he started micromanaging
victimised
her.
her.
Yeah, so definitely
so I think,
under multiple grounds.
Yeah, multiple grounds. So I think I just want to raise it because I think people forget general protection lurks there, particularly where someone hasn't been dismissed.
Yeah.
But there are 2 or 3 clever plaintiff law firms who would agitate this and seek an injunction as well.
Yeah.
So I'm just putting it out there.
And treating her differently because she was a woman as well. They would join all of these things under
and
the
they
one
would say
claim.
hostile workplace
Yeah.
as well. So
Yeah.
you'd also use that as the factual basis. They'd pick some other women that Conrad's not been good to and raise it. So the third question is a much more interesting question for us is,
were there any safety breaches?
And the answer is there's an abundance of psychological hazards. In fact, I think I managed to get most in there.
Yeah, pretty much.
Yeah, so the psychological hazards are present. So the next question is, given the nature of the psychological hazards, what is the nature of the breach that occurred? So we've definitely got a primary duty breach.
Yep.
But given the number of them that occurred and the victimisation, in other words, now you've raised this and now you treat her worse as a result.
Yeah.
In discrimination law, so that's the money claim. So there is a discrimination claim here too. We're not dealing with that at the moment.
But reckless endangerment is.
But reckless endangerment's proven. Okay.
Yeah, definitely against Conrad.
Conrad can't get away from it because he was aware of the impact because he'd been told of the impact. And with the knowledge of the risk of serious injury, not only was he careless, he was premeditatedly bad towards her.
And increased his behaviour.
Yeah, so, and I think Conrad is not. I think Conrad did form as an officer. Was he a member of the executive or not?
He was a member of the executive.
Yeah, so he's an officer as well. So industrial manslaughter is possibly there. This is something which will be agitated with industrial manslaughter. This case in 2 to 3 years' time will be an industrial manslaughter case, without a doubt, both the organisation and for Conrad. But the person who's really at risk in all of this, that's the hidden risk, is Nadia. So here as an officer seized with the responsibility of providing a safe place work was the person who managed the intervention and allowed it. She's off for reckless endangerment as well because she knew the risk and she was indifferent. She allowed it to go. She told him off, but she didn't take the step to prevent it. So interesting, I think it was an interesting case, and I'm raising it now, I guess, because now we have LH case, which talks about what are the tariffs. I think Conrad could be in jail.
Yep.
All right, that's it for this week.
Us.
Thank you very much. Cheers.
Yeah. Bye.
Bye-bye.